So thank you very much, everyone, for joining us here today. My name is Barnelli Chaudhary, and I'm the director of the Nathanson Center. It is my great pleasure today to introduce to you our speaker, Ambassador Bob Rae, who is the Ambassador and Permanent Representative of Canada to the United Nations in New York. Ambassador Rae has previously been the Premier of Ontario, as well as the interim leader of the Liberal Party of Canada. He's been elected to Parliament a number of different times, 11 times, I believe, is the record. Mr. Rae received his degrees from the University of Toronto, Oxford University, and he is unfortunately a graduate of our competitor school, U of T, but we are nonetheless happy to have him here today. He's going to be speaking to us about Canada's role in promoting transnational human rights at the UN, and I give the floor to Ambassador Rae. And if you could just hold your questions until the end, where we will allow for a Q&A. Thanks very much.
Thank you very much, Professor. Good to be with you. I'm sorry I didn't go to Osgood. I didn't get in, I guess, but I'm delighted to be able to speak to you. I've had the pleasure of speaking to the law school in person many times over many years, and I'm on many different topics, and I'm delighted to be able to join you for what I really consider to be more of a conversation, and if you'll forgive me, than a lecture. What I'll do is, with your permission, I'll talk a bit at the beginning, try to give everybody an overview, and it's pretty much a personal reflection. I was joking at the beginning with Professor Chaudhary that I didn't really want to mark at the end of this thing, so I'm sure I'll make some very elementary mistakes. But let me just try to put the issue in some perspective, and then talk about some of the current challenges that we face at the UN. You know, the issue of the universality of human rights is really a fundamental political and philosophical question. For me, speaking very personally, it's always been about two things. One is the dignity, human dignity, and how we respect dignity and how we respect autonomy. And the fact that these rights really do, in my view, pertain to human beings as a fundamental core assumption. So that's the first thing, just to put my cards on the table. And the second thing is that the protection of these rights is a continuing exercise. It's been I wouldn't describe it as an evolutionary process, because if you look at it historically, we've gone forwards and then way backwards and then forwards again, haltingly. But the architecture to protect transnational rights, or rights that transcend the principle of state sovereignty, really is a historical phenomenon, and a phenomenon that is still in play. And I think I hope to get to a logical conclusion of my remarks, and to point out how, whether it's at the International Criminal Court or at the ICJ or other institutional mechanisms, it's a work in progress, and it's highly, highly imperfect in many, many respects. At the core of the Charter, the UN Charter, there is, when you read the Charter, there is a tension that's at the heart of the Charter. And I always like to tell people that it's a tension that continues to play out every day. It's a daily part of my interaction with my fellow permanent representatives and with the UN system. The Charter borrowed from basic sort of principles, evolving principles of international law that really go back to the Treaty of Westphalia in the 17th century, that relate to the foundational principle of national sovereignty and the equality of nation states. Now, those principles were not particularly observed over historical circumstances and times. The history of colonialism, the history of warfare, the domination of empires, all of those things, in a sense, made a mockery of the notion of the equality of the nation state, because some states were obviously more equal than others. But nevertheless, that's sort of a foundational principle. It emerged from the end of the First World War very strongly with Woodrow Wilson's 14 points and with the foundation of the League of Nations. Although again, at the League, there were very much different categories of states, and the League of Nations made specific reference to trustee states and to the existence of colonial powers and of colonial stewardship. At the end of the Second World War, you'll recall that in the Atlantic Charter, there was this tension, again, sort of a contest between Churchill and Roosevelt over the issue of self-determination. Roosevelt was very determined, the Americans were very determined to get the principle of self-determination into the Atlantic Charter, which was the document that was originally signed by the UK and the US, off the shores of Newfoundland, and which was then signed by a number of combatant parties at the White House in Washington after the Americans joined the war effort after Pearl Harbor, and really became a sort of foundational principle of American foreign policy to support the process of decolonization, but also to recognize that, the equality of sovereign states. So that notion, that doctrine was in the charter, specifically refers to the equality and to state sovereignty. At the same time, in the charter, as in the Atlantic Charter, which is really an important document to go back to, kind of understand sort of how it made its way through to San Francisco and to the adoption of the charter, there was really a very key a language which was very, very clear on the importance of human rights. Specifically, the words are used on human rights, the rule of law, and that is therefore when there's a group of countries, led by Russia and China and containing a few other members called the Friends of the Charter, and their argument is, we got to go back to the origins of the Charter to get away from all of the other detritus that has been created since 1945 that gets in the way of remembering the core. It has its parallel in American constitutional debates around originalism, if you like, when you look at arguments around the American Constitution. But when it comes to our situation at the UN, I always make the point, always in speeches, always remind those who talk about some kind of doctrine of originalism at the UN to say, well, actually, if we follow the logic of originalism, human rights was at the core of the United Nations founding. It's at the core of the Charter. It's mentioned in several different sections of the Charter. And it therefore is part and parcel of the Charter. Now, not all international human rights come from the Charter. Many of them precede the Charter in terms of the laws of war, humanitarian law relating to the Geneva Conventions, and other ideas and doctrines which have emerged over a period of time. But it's in the post-45 period that I really want to focus. And don't worry, I will get up to date. I will get there. Whenever I teach courses, I always try to give people a bit of a background in terms of how did we get to where we are, and how does that help to explain our current challenges. The next logical steps come at the end of the 40s when several actual critical treaties and conventions were signed. The Universal Declaration on Human Rights, which a Canadian, John Humphreys, who was a distinguished professor at McGill University, and he was very much the pen, the drafter, didn't entirely draft it himself because there were many amendments and points made, but the Universal Declaration was a landmark document in terms of its declaration of principles and its affirmation of what I started out by talking about, which is the affirmation of human dignity and of human rights. And as not something that is not exclusively a Western doctrine. I mean, there is an argument that one hears frequently here at the UN that these notions of human rights are culturally specific, are not universally shared, and therefore, the Universal Declaration is not really universal. But I still think it's a very important foundational document, and I think if you want to look philosophically at many, many different cultures, whether Islamic or Confucian or many others. And Professor Leutbrecht also from McGill has talked about these ideas as having origins not only in Western cultures, but in Eastern and Middle Eastern cultures as well. And then you get to various conventions and treaties that have been signed, the Genocide Convention perhaps being the most important. And may I, by the way, really commend, if you can, reading a biography of Mr. Lemkin, who was one of the driving spirits, and such a critical leader in dealing with the impact of World War II and the concept. And the importance of recognizing that what took place in the Holocaust had a particular historical meaning and significance for all the rest of time. And I think that's something which, as we'll see when I talk a bit about the Rohingya issue going forward, how that's something which Canada is very much involved in engaging with and dealing with. So, through the 50s and 60s and 70s, there have been a range of treaties and conventions to which Canada has been a signatory, is a signatory, leading all the way up to the UN Declaration of the Rights of Indigenous People, which we have a very key history in actually drafting the declaration, but not a very distinguished history in terms of how we have embraced it. Although that I think is partly being remedied. So it's not simply the existence of treaties and conventions, it's also the existence of institutions. So at the present day, we have both the International Court of Justice, which dates back well in time before the First World War, and really flows from the original World Court that was set up in The Hague, which was a court of arbitration, but now goes beyond that to including a number of issues which are currently very live and very much in front of the court today, including the issue of genocide. Again, I'll come to that in a moment. The International Criminal Court, which Canada again was a major architect and signatory to. Professor Kirsch, Philip Kirsch, who was a public servant in the Department of Justice for many years, was very much involved in the negotiation of the establishment of the International Criminal Court and the ways in which crimes against humanity find a clear place where issues can be brought to bear at that court. The Human Rights Council and the Human Rights Commission in Geneva, which has a critical role in where issues of human rights can be discussed in a political forum, a forum that's attached to the United Nations. Of course, the General Assembly and the Security Council, organs of the United Nations, which have responsibility for the enforcement of human rights. All of which is to say, if you look at the history of the evolution of these charters, these conventions, these treaties, these declarations, and these institutions, you would have to say that we are today in a world where undeniably rights are recognized, rights are affirmed, rights are declared. But the challenge in all of these institutions is not just the affirmation of rights, or to start with, do rights exist? How do we affirm them? Where can we find them? What is the law around them? But the fundamental question is the issue of enforcement. And it's actually interesting, if you go back and look at the famous speech that Winston Churchill gave in Fulton, Missouri in 1945, was a speech, and that's the speech that's famous as being the Iron Curtain speech, where Churchill described in Churchillian language, if you'll forgive me, what the Iron Curtain represented. What he actually talked about in that speech was very interesting, because what he was talking about in that speech was, and it was interesting coming from Churchill, because, you know, a great imperialist, not somebody who one would say was a human rights champion in many, many historical contexts, but nevertheless, I think is a reflection of some lessons that he felt he needed to share. And he stated that, you know, the problem is, it's not just, you don't just need laws, you need a good constabulary. You need a police force, and he called for such a police force, which of course the Russians vetoed. And he also made a point of talking about the need for enforcement. If rights are to be real, they're only as real as our ability to enforce them. And that is the dilemma that we face today. The challenge that we face today in not only in international law, but in international politics, and in all of the institutions of the United Nations, is how do we deal with this gap between the rights and the lack of remedies. Going back to my law school days, you know, remedies are pretty important, and we look at, well, what are the remedies and how do they get enforced? And here I come back to, you know, to the fundamentals of state sovereignty. What makes the rule of law real in the national context, or in provincial context, or the local context, is the ability to have rights enforced. Is the ability to say, well, we know here's an instance where rights have been badly abused. What is the remedy? What is the mechanism for enforcement? And I think any observation would have to say we've made some progress in the field of enforcement. We've made some advances in abilities to find the appropriate remedies, but we face huge challenges, and that remains the case. That the challenges are very, very great. I want to just describe a few of them, and the challenges really relate to a couple of things. I think most fundamentally they relate to the nature of the architecture which has been built since 1945 and even before. Treaties are things that states agree to voluntarily. That's what makes them treaties. And by the way, one of the issues I think on the existence or the ability to enforce Indigenous treaties in Canada is whether they were entered into voluntarily. I just say that as an aside, because I think that's really quite a fundamental legal question, which has actually not really been adjudicated directly in Canada. It'll be a fascinating day when that actually happens. But I won't get sidetracked in that way, except to say that Indigenous rights are international rights as well as national rights, and a failure to enforce in Canada, I think lends itself to questions around, well, what can happen internationally when that takes place, and we need to be aware of that as we look at our situation. The question that is really, I think, the most difficult is that the institutions that we created since 1945 are highly imperfect. And I've used this line before in speeches because I like it so much, but I will use it here again. You know, I mean, think of Leonard Cohen's poem and song, Anthem, where he says, you know, there are no perfect offerings. There is a crack in everything, and that's where the light gets in. Well, let's first of all start with the first statement. The institutions that were created in 1945 are imperfect. They're imperfect because the people who created them were imperfect. They had competing goals and designs, they had competing objectives, and what they did is subject to different interpretations. That's as true of our chart of the UN Charter as it is true of our own charter, as it is, I mean, the notwithstanding clause. Having voted for the charter, notwithstanding the notwithstanding clause, one realizes right away its imperfections, because there's an issue of enforcement, isn't there? If a provincial or federal government decides to limit the role of the charter, then that's something we have to engage with as Canadians. We have to recognize that's part of our laws, part of our politics and our policy as well. Same thing's true of the UN Charter. The creation of a Security Council, which had really sort of overall arching responsibility for matters of security, and it has an impact on issues like references to the International Criminal Court, which are also automatically can go to the International Criminal Court from the United Nations. They go via the Security Council. So therefore, the existence of the veto, the 5 vetoes of the 5 permanent members, is a huge problem. It's a huge issue. It limits the willingness of the Security Council to ever refer a matter of a crime against humanity in any state to the International Criminal Court. Therefore, it limits the ability of the International Criminal Court to deal with. The International Criminal Court is the product of a treaty to which a number of countries are signatories, well over 100, but that means 193 countries in the UN. That means that dozens of countries, including very important ones like Russia, like China, like the United States, the list, like Saudi Arabia, the list goes on and on, are not signatories to the Rome Treaty, which gave rise to the International Criminal Court. So that's clearly a limitation in the jurisdiction of the court. A limitation of the jurisdiction of the court means that there are things it can't do. So, for example, in the case of the Rohingya, it's an interesting case, and I like to think that the work that I did on the Rohingya may have helped to galvanize a number of countries to think more about, well, what could one do to get the issue of the Rohingya in front of the International Criminal Court? 2 routes, because Myanmar is not a signatory. So what do? Well, Bangladesh is a signatory, and the crime against humanity known as forcible deportation really is not completed. That crime is not completed until the deportees have arrived at their point of arrival. So that arguably, and this is the point that Canada has been making to the court, is the reason why there is jurisdiction. Could be right, could be wrong. We'll see. The prosecutor is looking at it. There's been no definitive finding yet by the court as to whether that's the case. But at least it's an argument to say, well, that's why it should be in front of the International Criminal Court. Just focusing a bit on the Rohingya issue shows you the trouble, the challenges we face. The next challenge, of course, is, well, if it's a matter of genocide, genocide is a treaty between states parties. States parties can bring another state in front of the International Court of Justice on the issue of genocide. It's been done in a number of cases in the Balkans, and most recently on the Rohingya issue. Gambia brought forward the case with Canada's support and the support of the Netherlands. We're now intervening in the next stage of the case, focusing on issues of acts of genocide involving women, and that is a particular issue which Canada is raising and Canada is pursuing at the ICJ. Whether we will succeed or not, we don't know. But obviously, it's been one of the really significant issues that we face in bringing these cases forward is how do we get information translated into evidence. And how do we get that evidence broadly accepted by the court? And that's true in the ICJ cases. It's true in the crimes against humanity cases at the ICC. And I talked about this in the report that I wrote on the Rohingya, which came out in 2018, where I set out, some of the challenges that we would face and we are facing in order to bring reliable information, documentary information, and evidence being provided by witnesses whose evidence will stand up in the face of significant attack, and how that works. The other line that we've taken that I think is of interest, and I'll wrap up shortly, is something called the independent mechanisms, which we've established in Geneva. We've established independent mechanisms in both Syria and Myanmar, with the objective of gathering evidence and gathering evidence that can be used in an eventual tribunal process. Now, it's highly imperfect. We're gathering evidence for trials for which there is currently no venue. So the Russians and the Chinese and others who object to these independent mechanisms say, well, what's the point of bringing forth evidence if you don't have anywhere to take the evidence and you don't have any basis upon which to do it? Why are we wasting our time and money in gathering evidence? And the answer is because evidence is the critical basis upon which we establish a world in which people are accountable for their acts, and in which people are held accountable, in which there is no impunity. And that's a fundamental principle of the rule of law, that people should be held accountable for their actions and for the consequences of their actions, and that states should also be held responsible for their actions and for the consequences of their actions. And so without evidence to do that, we will not be able to build the building blocks that make for an effective enforcement of human rights around the world. I guess what I'm going to do is, Professor, with your permission, is just kind of sum up what I've said, and also some, I think, obvious questions arise and issues arise. I mean, the first one is, do we believe that there is such a thing as human rights which transcend national boundaries? The answer for Canada is yes, we do. We believe in them, and we also believe that they apply to us. We do not believe that we are exceptional or immune, or somehow that these things are not going to apply. Our American friends are not signatories to the ICC, and the continuing assertion of exclusive American sovereignty over these issues is frankly problematic from my perspective. We believe these issues arise around the world, and we believe there should be solutions found to them, and we believe they should be addressed, and we believe they apply to ourselves. We don't make an exception of ourselves, and this is very important. Frankly, it's one fundamental thing that gives us credibility when we talk about human rights. When I raise human rights issues in the General Assembly, I can now expect to be criticized by whoever I am criticizing, saying, well, what about this? It's whataboutism, right? I mean, the Chinese, what about the indigenous? What about other abuses? What about colonialism? What about your own record? And my answer to that is to say, well, what about it? We're ready to be judged. We're not asserting that we're not subject to the same rules. We're not asserting that we're not part of the global community, that somehow our laws are different or better than anybody else's. We accept international law. We accept the jurisdiction of the ICJ. We accept the jurisdiction of the ICC. We accept the Universal Declaration of the Rights of Indigenous People. The government of Canada is now, I hope, will be able to, in the next Parliament, bring in a law which will clearly indicate the steps that we are going to take to entrench the Universal Declaration of the Rights of Indigenous People into our own legal structures at the federal level. I believe the province of Ontario should do the same. I believe provinces should do what British Columbia has done. So these are sort of basic ways in which we act. We're also parties to cases. We're advancing cases, and we advance them not only in courts, but we also advance them politically. Because to conclude, this is a matter of law, but it's also a matter of politics, and in a sense, politics writ large. How do we create the institutions that will actually be able to create remedies? That, I think, is still the question. And the answer to the question is, with great difficulty, but with persistence, we can actually make progress. So I'm in your hands.
Great. Thank you very much for that very engaging talk. I'm wondering if I can open it up to the audience to ask questions. I have many questions prepared, and I'm happy to take over this debate, but I think I should allow those of you to ask questions. And if you could use the raise hand function, that would be great. Obi, why don't we start with you? Oh, you're gonna have to unmute, Obi.
Oh, yeah, sorry. Thank you so much, Ambassador, for that presentation, and thank you for your service, national and international. I agree with the general thrust of your presentation, but as you know, the devil is in the details often, right? So, so I want to push you on just a bit, in a friendly way, on one point. And it's a point on which I think a lot about often, partly because of where I was born and lived the first 26 years of my life, and it's complicated because of that, and partly because I'm an international lawyer. So I tend to think of this, and I think about issues of effectiveness like you, and legitimacy and so on, and the power really of legitimacy, which I think is partly what you're getting at. And I agree entirely that there is a difference, and I see it at the UN. I'm a special rapporteur myself. I see the difference between being Canadian and being American. It's just, I haven't done an empirical study, but you just feel it. There's a difference. Or countries like Scandinavians, when they speak, right, to certain other countries, the credibility is just more robust. However, I want to push you a bit more. Is it really enough to take that stance and say, well, the law also applies to us, international rights law? Does it really, in the way it applies to weaker states, right? Because I hear this a lot. Believe it or not, even well-meaning individuals and groups, when they go to The Hague and every cell there is filled with an African. One of Nigeria's greatest human rights advocates was shocked when the first time he went to Scheveningen. And it just conjures certain images, right? Conjures up certain histories and thoughts. Even as he formed the African support group for the ICC. So even for the friends of the ICC, things like that can be disturbing. So does it really apply in the same way? I mean, I have a Natal Francis law. Often I use that in my, it's all and good to say the law formally applies to the powerful and the rich. And here I'm talking about, and that no one should sleep under the bridge, but we do know it's always gonna, the rough end, in a rough and sort of the strongest points of the law are going to always apply in a much more robust way to weaker states. And it's not just at the global level. It's the same thing, say, on the West African level. It's all well and good for ECOWAS to remove the recalcitrant Gambian leader, but we're to be the Nigerian leader, not no such thing was going to happen at all. And we all know that. So I see that, and that chips away at the legitimacy as well. And in the sense that there's always this argument that you hear that, it's one law for the powerful and one law for the weak. So I know it's a difficult question. I don't know the answer myself, personally, but I just wanted to push you as an experienced hand on this issue. Thank you.
Of course, you're right. I mean, in the sense that, historically, and not just historically, today, this is why I say it's partly a matter of law, it's partly a matter of politics. And I think we all understand that creates inconsistencies, and it creates challenges for the ICC, for debates at the UN. I mean, what I started by saying was that look at the existence of the veto itself means that particular cases or examples of abuse of human rights or crimes against humanity in one country or another, and the fact that many countries are not signatories to the Rome Treaty means that the treaty is not universal. So it doesn't include a lot of countries that you'd say, well, why not bring that? And you say, well, the prosecutor may say, I can't get the evidence. The prosecutor may say, I don't know we can't find people to come forward and testify. And that's true in Canada, right? I mean, why are some cases not prosecuted and others are prosecuted? Why are some charges dropped and other charges are not dropped? There's prosecutorial discretion in Canadian law, in Canadian institutions. And, there's lots of studies done by criminologists and others who will say, well, it's interesting, isn't it, that you choose to charge these people, but you don't choose to charge those people. That's what makes it imperfect. So I don't think we're disagreeing. I think the hard part for me we all come from different backgrounds. And my father was a diplomat. I come from an upper middle class background, if you like, in terms of the stratosphere that I live in, and I recognize that. And these are limitations; these are cultural limitations on my part, and I spend my life trying to overcome them and transcend them by feeling that a human experience is not unlearnable and that you can't approach it from different directions. But I think it's fair to say that my attitude, I mean, even the way I see things is we're making some progress. Have we made enough? No. But I'm always somebody who says the glass is half full, or it's a quarter full, or it's a little bit full. And there are those other people who say, it's all bullshit. Nothing's really moving forward, and it doesn't do much for a lot of people. And I understand that level of frustration. It's just not where I come from. And I try to see how can we make it better. I would also make one other point, and I am now the vice president of the Assembly of States Parties of the ICC, and have been involved in a lot of discussions about the ICC over the last year. And I'll be going to the ICC meeting in The Hague in early December. I think the court is very aware. I think the Assembly of States Parties are very aware of the fact that there are challenges and there are issues, and I do think that the court is really working to try to create a stronger base of credibility with around the world. It's not made any easier by the fact that a very substantial number of countries representing billions of people do not adhere to the Rome Treaty. They will not sign it. And we haven't had a lot of new signatories in the last while. So we need to understand that this is kind of like an existential question. Is, how far have we gone? How far can we go in the face of states parties saying they're not going there? And so that's a realpolitik situation we have to deal with.
I'm wondering if we can allow Craig to ask his question because he has to leave. I know we're already pushing the time, but Craig, do you think you can quickly get it in there before you leave us?
Yeah, thank you so much, Bernali, and hello, Ambassador Bob.
Craig, good to see you.
Good to see you too. Bob, I wanted to, I could have a soliloquy, but I just wanted to ask two quick questions and see, because I think you know I'm coming from both. One is, despite what you've said about Canada accepting obligations, I think it wouldn't take long, it would take you 5 minutes, but it wouldn't take long to show all the ways in which our system is not actually a very well adapted system to implementing or complying with international human rights law. So what we do in the international space at the UN is one thing, but how it comes home to roost is another. And I'm wondering if you know, courts are patchy, if not still recalcitrant, executive finds all kinds of dodges whenever decisions come down from UN treaty bodies, etc. You know, Alex Neve, who you'll know, is starting a cross-Canada implementation project because of how poor our parliamentary system accommodates even accountability review for the executive with respect to international human rights treaties. And we actually are pretty pathetic when it comes to some other systems that have much more structured committee review structures, say Finland. And as you'll remember from your days in the House, you know, we have a subcommittee of the Foreign Affairs Committee that is a human rights committee that plays none of these real roles, right? There's nothing that comes into the parliamentary system that looks at all like what, say, a privacy commissioner or an information commissioner might do in a very holistic way, looking at what's Canada doing and putting pressure on the government through reporting. And we have no real mechanism. So what I'm wondering is, given your lifelong involvements and your time in Parliament, would you agree that Parliament has really fallen down for a very long time as an institution that needs to step up and have different mechanisms, at minimum a robust committee, if not an officer of Parliament, that really holds our own feet to the fire? This is an expression you used to me many years ago during the social charter discussions, that things sometimes only work if we create mechanisms where we're burning our own feet. The second question is, you refer to, did you intend to refer to the Sands book, East West Street? Is that? Yes. Yeah. So the Raphael Lemkin and Lauterpacht story, it's a fascinating book, and I do recommend it to everybody. But you'll recall, but you'll recall that one of the driving narratives for Philippe is Lemkin's insistence that genocide existed, needed a word, and that harms to people for their collectivity, ethnic, racial, etc., have to be named and have to be their own human rights claim and crime. And Lauterpacht was very much not so on board with that, and worried that, say, crimes against humanity as a term is a much better term, more capacious, and one that still gets us looking at individuals in a way that he worried about the rest. With all your experience, say, in Myanmar, and knowing that over the years, these semantic games and fears that go into using the genocide label, getting inside that characterization, the semantic politics around, if we can just get it called genocide, something different happens. Do you have any feelings on that as to whether or not Lauterpacht's fears might well still be valid?
You know, it's a great question. On your first point, I agree with you. I think the other point about Canada is that it's not just international human rights. It's the extent to which we have not really internalized the Sustainable Development Goals, either federally or provincially or municipally. So, you know, we are not perfect international citizens. If you said, in terms of how have we created the institutions internally that would allow us to say, well, you know, how are we doing on the SDGs? You can imagine a report card on the SDGs that would be contained in every budget. Similarly, you know, our obligations under the Paris under the Paris Agreement and under other, climate change. We're going to, we have signed environmental treaties on climate change going back to Kyoto, and we have not lived up to them. So, I mean, I'm not making a contentious political point here. I'm just stating a fact. It's an undeniable fact. So that leads one to believe that, one of our problems is we don't have adequate accountability mechanisms in Parliament or at the level of the provincial legislatures or, frankly, elsewhere. So, yeah, I agree with your first point. I think it's a very fair point. I think it's an important one. On the second one, I do think the debate is what has troubled me about the debate around the genocide issue is that it becomes the G word. It becomes sort of, are you ready to say it? Oh, we use the G word. Oh, and you sort of say, look, I mean, it's a crime against humanity is bad enough. I mean, it's not as if you say, well, you're only describing a crime against humanity. So, well, that's pretty bad, right? A crime. I mean, a genocide is a crime against humanity, but it's also something more because of the Genocide Convention. So I don't want to kind of, I find the debates around, have you met the conditions? Is it this? Is it that? Much less important than the challenge we face in getting major crimes against humanity, of which genocide is certainly one and the most serious in many respects. The difficulty is where do we go with these things? And I think what animated people to establish the ICC was to say there's no point in having a crime against humanity and then say, but there's nowhere that can be punished, or there's nowhere that people can be held to account. So, I mean, I do think Philip Sands' book is a wonderful book, and I think his thoughts on this are really really interesting. I actually had not met him until the Myanmar case, where he was one of the counsel for Gambia. So I had an opportunity to spend some time with him, and it was really a very, from my education point of view, a very worthwhile experience, just talking through these issues with him. I also have to say that I think it's a sad fact that there are, under the definition of genocide as it is stated in the Genocide Convention, it is a more widespread problem than we're prepared to admit.
Absolutely.
And therefore, one of the things that we need to do is to take the sense that the word is unmentionable. And that's why in the report that I wrote on the Rohingya, I said, well, here's what it is. Here's the definitions. Parliament and the government are going to have to decide whether it meets the test. And here's all the facts that we found so far. And this is how one would build a case. And I think that's sort of what's happening, but it's the process by which it happens is very, very slow and very, very painful. I don't know if that answers your question, but I think it is a very good points that you raised. And it's good to see you.
Yeah, it's good to see you. I'm going to have to drop at a site because a bunch of students.
I understand. We all have work to do in some way, shape, or form.
We all have work to do. A bunch of students who might get placements around the globe for these kinds of purposes. So good to see you again. Sorry, everybody, for intruding. Good to see you. Bye.
Thanks, Craig. Are there other questions from the audience? Nobody else? Okay, then I guess it's going to be me now for the rest of the time, Ambassador. So let's start with the first question. I'm not sure whether the students know about this, but Canada recently lost its bid to be on the Security Council. And I'm just wondering if you can comment on, I read your remarks that you gave to another talk where you said that, this was an election, we simply lost an election, but I'd like to think of it a little more deeper. That is, what is Canada's role in governing at the UN level, given that they don't have a seat on the Security Council? And second, related to that, is there a plan to eventually go again for a seat on the Security Council? And even more provocatively, do you think, and I appreciate if you don't want to answer this question, but do you think that we should work towards restructuring the Security Council to remove, I would say, the permanent member seats, that there should be a new direction in that area?
Well, totally. I mean, that's first of all, I have no hesitation in answering your last question. Canada's made it very clear. We made it clear in 1945 that we didn't like the veto. Australia and Canada were, we're not happy. We sacrificed a lot to to get to the table in 1945. A lot of Canadians died. We were, we spent billions of dollars at the time. We were a major combatant in Europe and in the Pacific. We were present throughout the process. We were present at the creation, if you like. So we were not in favor of the veto. The veto was imposed on all of us by the five, and it was a price of, that's why I say these documents are imperfect. The process of getting there is imperfect. Part of a compromise, and we're part of a group now at the UN that is arguing in favor of expanding the council and allowing for longer terms for non-permanent members, and a number of ways in which we think that the council should be reformed. Getting it reformed is very difficult because, hey, guess what? The charter, in order to amend the charter, you need 2/3 of the General Assembly, which is about 130 countries, and you need all 5 permanent members, which means the Russians, the Chinese, the Americans, the Brits, and the French all have a veto. So we imagine how quickly this process has been going on. It's been going on for 20 years. Canada is very much part of it. I think it's important to stress that the Security Council seats for the non-permanent members only last 2 years. And at the time in which we were elected on a regular, fairly regular, over a 10-year period, we would be elected once every 10 years. The UN was a much smaller place. The club was much smaller. And we said, well, we'll take our turn in the rotation. And since, the last, right now we have 193 countries. So, there was no guarantees that you'll ever get on. We get on from what's called the WEOG group, which is the Western European and others. And we've not had a clean run. We've not had a clean slate of countries out of WEOG. Whenever we presented ourselves, guess what? The Western Europeans favor the Western Europeans. We're in the other group, and we don't have as easy a task at getting a clean slate. So the good news, that's the bad news. The good news is there's a lot of ways in which we can and do participate in the governance of the UN that has nothing to do with the Security Council. The Security Council is not like the executive body exactly. It deals with matters of peace and security, which are obviously critical. So does the General Assembly. We're active, we're the top 10 donors to the United Nations. We're active contributors to the UN at every level, to every agency. We're recognized as such. And we participate actively in many, many different ways. The Peace Building Commission, of which I was the chair last year, ECOSOC, which is a body of the UN, which was created in 1945, which deals with economic and social matters, where Canada has played a particularly strong role over many, many years, and various informal ways in which we create groups to say, how are we going to address this question? So Canada played a leading role in the discussion that's taken place at the UN on how do we finance development in the age of COVID? How do we respond to COVID? And how do we finance development in the age of COVID? So we're very active in the climate change discussions. We're very active in dealing with particular conflicts like Afghanistan, like Venezuela, like Haiti. I chair a committee on Haiti for ECOSOC. So there's lots of ways in which we can and do play a strong and vibrant role. But the UN needs reform. The General Assembly needs to be reformed. The Security Council needs to be reformed. And Canada is very much part of that reform process. Will we present ourselves in the future for the Security Council. That's a decision for the government. My recommendation is that we need to stay engaged in every way we can, but we need to pick our spots in order to ensure that we don't simply run in order to lose. So there's no point running if you're up against countries that you know have been in the field for a long time, and that's every 2 years. So the plan right now, the slates are filled until the late 2030s. So we have to make a decision about how we're going to go forward. And I'm sure that's something that will be on the plate of the new foreign minister when he or she takes office next week, whoever it is.
Okay. All right, then I'll continue with mine. So another question that I'd like to pose to you is this idea of the common agenda that the UN Secretary General has proposed. And I understand that the proposal is to create a new social contract, which sounds fascinating. And I was just wondering, what is Canada's take on this new contract, and whether or not you think that the member states will be able to form a consensus on the content of this social contract?
Well, I think what the Secretary General is doing with his presentation of the common agenda, which he was asked to do by member states, saying we need to have a document around which we can debate and discuss going forward. And the Secretary General did that, I think, with great distinction in his report, the common agenda. The central message of the report is that one with which I think it's very difficult, well, with which I agree. I think Canada would instinctively agree, and that is that climate change, conflict, COVID, the pandemic have all had a dramatic impact on the relations between and among countries and the peoples of the world. And we need to understand the extent to which it is these crises have exacerbated inequalities. They've driven us backwards in terms of the Sustainable Development Goals, and we need to go forward in a new way. We need to reaffirm our commitments to each other, and the central principle of the one word principle of the Secretary General's document is solidarity. Do we have solidarity or not? And if we don't have solidarity, why don't we? And what can we do to get there? And I think that's undeniably true as well. I think it is true. I think that is a fundamental question. The really interesting question that the Secretary General poses is, what about future generations? It's actually a Canadian, Mark Carney, former governor of the Bank of Canada, who created, I think, a broader understanding of the fact that we talk for a lot in economics and in politics about the tragedy of the commons. What do we do about ensuring the governance of the public space, and how does the public space compare with the prosperity of the private space? Galbraith talked about that in his book, The Affluent Society, which was a very important sort of analysis of where the world was going in the 1950s. What Mark Carney talked about was what he called the tragedy of the horizon. That is to say, if our time frame is limited and our scope looking forward is limited, then we are really missing the point about what's the fate of future generations. In Indigenous thinking, we talk about, and actually the Secretary General talks about this, the importance of thinking in a 7-generation way. What's the impact going to be in 7 generations? I think one of the things that climate change is doing to us is forcing us to think more about the future, and forcing us to think more about what is our obligation to future generations. And so what the Secretary General is trying to do is say, can we create institutions which build in more the consideration for the future? How do we give youth a stronger voice? How do we give a greater presence to young people in everything that we do? I think that's absolutely correct. I think it's very true. I think that there are voices that are not at the table at the moment. And look at me. I'm I'm an old white guy. To what extent do I speak for for future generations and for the central values of inclusiveness? I'm very self-conscious about that, and I think it's really important for us to think about the institutional ways in which we respond. Ironically, and the Secretary General doesn't refer to this in his book, but in his report, but it was a conservative, Edmund Burke, who talked about the social contract, and he specifically talked about a social contract is involving the past, the present, and the future, and somehow understanding that for Burke, that was the central importance of institutions. That's why institutions matter, because institutions are the way of ensuring that the past has a role, present has a role, and ideally the future has a role. And I think that's the key challenge when we look at what's happening in the world today. How do we build future thinking into the life of the UN? And Canada's very supportive of the SG. We've talked to him about how we can help to create bases of support, because some practical things that flow from what he's talking about that I think are important to consider. But I think his report is a very good basis for our discussions.
Great, thank you very much. Carolyn, you've got the floor.
Oh, thanks very much. Good evening, Mr. Ambassador. Talking to you from The Hague, actually, in the Netherlands. I'd like to actually jump back to that part of your discussion that related to accountability for international crimes and the ICC. And I've actually been in that business for a very long time. So just to give you that kind of background as to where my question comes from, you asked the question, you posed the question about international justice, effectively in the future of international justice with the ICC in mind. Where do we go from here? Now, with that in mind, I wonder if you might be able to say a few words about complementarity, because after a career in the business, speaking for myself, I really see the future of international justice as one that can be built from a sustained national commitment to complementarity. And I'd like to know your views on that and whether or not you think Canada might have a role to play in that regard.
Well,
Thanks.
I think you're making a very important point. I mean, I think the debate between those people who insist on state sovereignty and those who insist on transnational justice is kind of getting stale. It's not a productive discussion. I mean, it's not a productive debate, although it dominates a lot of the airwaves, certainly at the UN and the General Assembly. And I do think that creating more effective national institutions is not opposed to international justice. It's actually part of international justice, and I think that's part of what Craig was talking about. And I think that's an extremely important point. I think one of the key issues is how do we ensure that states parties, and this has, this connects to R2P and a lot of other things, but because the first responders to R2P, the first responders to crimes, including crimes against humanity, are nation states, and it's only when nation states completely fail to respond or are unable to respond or don't have the institutions to respond that that the international response is supposed to be there. That's the sort of basic fundamental principle involved. So I think you make an excellent point. I mean, I'm not pessimistic about the future, precisely because I think well, first of all, I think the international institutions are improving. I believe that, and I think they're learning. And they're relative. Many of them are. I mean, the ICC is very new. We shouldn't expect miracles at the beginning, but I think things are improving. And I think the other thing that can improve is if a number of countries, including Canada, begin to address more clearly their own obligations with respect to the conduct of their own citizens, and that I think is very important. And I think one of the tests will, continues to be for Canada, continues to be how we deal with and respond to issues around Indigenous rights, because I think they are very, very much connected to our international obligations, and I think it's it has been an important feature of our national rhetoric that we accept these obligations. But I think there's always an issue of the rhetoric versus the action, and that's, I think, something we're going to have to continue to face up to.
Thank you.
Great. Anybody else? All right, I'm going to abuse my privilege as chair to ask one final question, Ambassador, only because it's so, this is an issue that's very close to my heart. I do a lot of work on transnational corporations and their effect on human rights issues. And I do quite a bit of work with the UN Working Group on Business and Human Rights. And I wanted to know what your take, or actually Canada's take, on this issue is, given that we don't actually have any laws that deal with these kinds of issues. We're not following the lead of the European nations that are coming up with laws to come up with this. At the same time, we're also not party, or we won't be party to the Business and Human Rights Treaty. We're not currently participating in this. So given that we don't actually have any mechanisms for holding corporations actually accountable in these kinds of issues, and you spoke so eloquently about the need for remedies for human rights victims, I was wondering if you could just sort of comment on that.
Well, it's a highly challenging political environment to discuss this in terms of corporate social responsibility, both nationally and internationally. I think this debate will unfold. I don't think it's over at all. I think it's going to continue to be a significant one. I know that the government, our government so far, has limited its interventions in terms of accountability to a kind of voluntary enforcement and discussion and way going forward. And I was very much part of earlier discussions in Parliament about whether the laws should go further. My colleague John McKay was somebody who brought forward some legislation in the form of private members bill, which I supported at the time, and philosophically I still do. I mean, I can't interfere and comment on any issues currently or not, either before or not before Parliament, but I do think it's something that we're going to have to continue to participate in. Yeah, I mean, I think it is an issue where we need to really look hard at what other countries are doing. And I mean, one of the main arguments that was often used by Canadian companies is the extent to which this creates a competitive disadvantage for them compared to corporations working out of other countries which do not have such standards or requirements. My own view is that it's important for wrongs to have remedies, and that's an important principle for us, and we need to follow the ways and methodologies that others are finding useful to get us to that point. So I hope we can move in that direction. Certainly look forward to welcoming you in New York and to any discussions which are taking place, and we'll be delighted if you'd like to come down and talk to people here about it. And I know you'll get a very welcome response from our staff here to engage in these issues, which are important to us.
That's great. Thank you very much. I may take you up on that invitation. If there are no other questions from our audience, then I think we will call the session to an end. Thank you very much, Ambassador Ray, for giving up your precious time to spend with us today to talk about the role of Canada at the UN. And we wish you all the best of luck in your continued activities. Thank you very much.
Thank you very much. I didn't have my lunch, but I had lots of food for thought. So thank you. Appreciate it.
Thanks.